Good morning, everyone. Welcome to this event organized by the UP Law Technology Law and Policy Program entitled Content Moderation and Human Rights on Facebook and Instagram, a discussion with Meta's Oversight Board. This morning, we will be having an exciting conversation on how the Oversight Board ensures respect for freedom of expression on both Facebook and Instagram, its processes for reviewing cases, and how it applies international human rights standards to its work. I'm Jenny Domino, and I will be moderating today's event. We will have an open forum later, so please drop your questions on the chat box or on the comment section if you are watching this on live stream. To start off the program, I would like to invite the Dean of the UP College of Law, Dean Edgardo Carlo Vistan, to deliver the opening remarks.
Thank you, Jenny. And hello, everyone who are in attendance in this webinar. Welcome to this activity organized by the University of the Philippines Law Center's Technology Law and Policy Program. Accountability in and regulation of social media and the tech companies that run them have been topics of much discussion and debate in various circles. The 2020 documentary film, The Social Dilemma, depicted many of the problems and issues attributed to social media use. Whether or not one agrees with the views expressed in that film, one undeniable takeaway from The Social Dilemma is that many industry insiders have come out to expose issues that call for accountability of the companies that run social media platforms. Similar calls had been made before the film came out, and similar concerns continue to be expressed today with more government leaders, joining the campaign. In the meantime, about 4 months ago, Facebook changed its company name to Meta Platforms Inc., or simply Meta. In its Facebook homepage, Meta declares that it is helping build a future where people have more ways to play and connect in the metaverse. Meta further implores its users to create a safe and respectful online space and to treat everybody with respect, and declares that comments violating its community standards will be removed or hidden. The Oversight Board, of which we hope to learn more about today, began its work around a year earlier, or in 2020, and was conceived and organized even before then. Created by what was Facebook at that time, but meant to be independent, a major part of the oversight body's work involves reviewing and making decisions that are binding on Meta with respect to the content-related actions it makes in Facebook and Instagram. Since it began its work, the Oversight Board had made decisions overturning as well as upholding content decisions of Meta. Balancing free speech and safety is the declared goal of the Oversight Board, but this is in a Facebook page where Meta also declares that it created the Oversight Board. This is why we appreciate and thank our guest for this webinar, the Oversight Board's co-chair, Professor Jamal Greene, who is joining us from the other side of the globe, I believe, for graciously accepting our invitation to share with us the Oversight Board's own perspective of its mission and work. The Meta Oversight Board setup represents a species, or rather a modification of a self-regulation framework that has drawn much interest, from those into free speech and human rights to those who study regulatory structures and processes. We all have much to learn from the co-chair of the Oversight Board. Again, thank you, Professor Greene. And as I end my opening remarks, let me also thank our organizers in our Technology, Law, and Policy program for this learning opportunity. Finally, let me express my gratitude to all of you who are attending this webinar for joining us today. Thank you, and I wish you all a pleasant day.
Thank you very much, Dean Bistan. Our main speaker today is Professor Jamal Greene. Professor Greene currently serves as co-chair of the Oversight Board. He is the Dwight Professor of Law at Columbia Law School, where he teaches constitutional law, comparative constitutional law, and the First Amendment, among others. He has also been a visiting professor at Harvard Law School. Professor Greene is the author of the book, How Rights Went Wrong: Why Our Obsession with Rights is Tearing America Apart, which was published last year. He is also the author of numerous law review articles and has written in depth about the US Supreme Court, constitutional rights adjudication, and the constitutional theory of originalism, with his scholarship appearing in the Harvard Law Review and Columbia Law Review, among others. Professor Greene is also a sought-after media commentator on the US Supreme Court and on constitutional law. His articles have appeared in the New York Times, Slate, New York Daily News, and the Los Angeles Times. In 2019, he served as an aide to then-Senator Kamala Harris during the Senate confirmation hearings of Justice Brett Kavanaugh. Prior to joining Columbia Law in 2008, Greene was the Alexander Fellow at New York University School of Law. He served as a law clerk to Judge Guido Calabresi on the Second U.S. Circuit Court of Appeals and for Justice John Paul Stevens on the U.S. Supreme Court. Let us all welcome Professor Jamal Greene.
Thank you for that introduction, and thank you for this invitation to speak to this audience. Thank you to the UP College of Law. It is a pleasure to be here. It's a pleasure to gaze into the future in some sense, in that it is tomorrow that I'm looking to. It's the day before for me. I'm going to just say a little bit about the Oversight Board by way of introduction to give people a sense of what the board does, what its mission is, and how it operates. And I'm, of course, I welcome questions afterwards. Those questions can go in any number of directions, and so I will not preview what the questions might be, but I'll say a little bit about of basics about how the board operates. You already know a little bit about its origins. It was created by the company that was then referred to as Facebook, and is now Meta. But it's an independent body in that it's not part of the company. The board's members are not Facebook employees. And the overall purpose of the board is to bring together these independent members from around the world and have them make binding decisions on content on Facebook and Instagram as a final round of appeal. That after content goes through Facebook and Instagram's own internal process, it then can be appealed to the board. And we make decisions about pieces of content, not only based on the particular community standards on Facebook or the particular community guidelines on Instagram, although one of the things we do is make sure that they're acting consistent with their own standards. But in addition to that, the board also evaluates Facebook's decisions on the basis of international human rights principles, including respect for freedom of speech, but also other rights understood within the international human rights regime. The board was first got up and running in May of 2020, but we heard our first cases or started taking our first cases in October of 2020. And in trying to select cases, since we can only hear so many cases, right? There are thousands and hundreds of thousands of cases come in every quarter, and we can only hear a small number of them. And so the board tries to select cases that represent especially significant or difficult content moderation issues, and cases that have the potential to affect a large number of users. So far, the board has taken 23 cases from around the world. More than half of those cases have been cases coming from the global south. The board is an international body, so the 20 current board members come from around the world. And through these cases, the board has been able to examine a wide range of issues that arise on a regular basis on Facebook and on Instagram. That includes issues around hate speech, issues involving violence and incitement, issues around dangerous individuals and organizations, and issues around public health related misinformation. So far, through the public comment process that the board has, which I'll describe a little bit in a little bit greater detail in a moment, the board has heard from more than 10,000 individuals and organizations from around the world. And in those, of the more than 20 cases the board has heard, it's actually overturned Meta's decision in 16 of those decisions. And those are binding on the company. So when the board says that the company took, or that Facebook or Instagram removed a piece of content and that they have to restore it, they have to restore it. And if the board says that they should take down something that they've refused to take down, they also are required to do so. So even though the board is independent and is not part of the company has a contractual obligation to comply with the decisions of the board. In terms of the board's process, I'll say a little bit about the process involving individual cases, and then say very briefly something about another hat that the board wears, which is as a body that also makes policy recommendations to Meta. So the board has a 90-day process during which it can hear a case. That clock starts running when a case is assigned to a panel of the board. So we have 20 members, but we hear cases initially in groups of 5. And then those groups of 5 deliberate about a case, and then the full board has to vote on the case outcome. So we have a 90-day period during which we can deliberate, you might ask, what are we doing during those 90 days? And there are a lot of different steps that it entails. So first, as I mentioned, a panel of 5 board members are randomly assigned to hear the case. Among those 5 board members are included at least one board member from the region that is affected by the particular content at issue. And after the case is selected, as I mentioned, the board opens up a process where it takes public comments. And that is an effort to allow people from around the world who may have a particular perspective or particular expertise to offer on a case to provide information to the board. And this is really, I'll just make a plug for the participation of people on this webinar in the public comment process, because this is really something where it would be helpful to have engagement from people within this community, including law students, including faculty or researchers who have a valuable insight to offer into particular decisions that the board is deliberating about. So the board is looking both for subject matter expertise, so people who might have expertise on hate speech or on LGBTQ issues or on misinformation or any number of the topics that the board deals with on a regular basis, but is also looking for people who have expertise in terms of local context. Because one of the challenges for a company that is a global company like Meta, and then the board trying to review its decisions, is to be able to have enough local knowledge and local expertise to make the right decisions in these cases. And as law students, you all have both subject matter expertise, and in some cases may also have important local context to offer. In addition to the public comments, the board also engages with experts and with researchers to learn more about a particular issue. So we don't just rely on the public comment process, but we will also reach out to learn about language context, or learn about local context, or learn about the background history of a particular issue that the board is deliberating about. After a panel deliberates about a particular case, the panel will draft a decision. The full board will review the decision, will make comments on the draft. There can sometimes be some back and forth about how the draft is constructed. And then there's a full board vote to ratify the particular decision of the panel. As part of those decisions, we don't just necessarily say Meta has to leave a piece of content up or has to take it down, although that's an important piece of every decision. But in most of the decisions the board has issued, it has also issued policy recommendations, right? So about how a particular community standard should be enforced, or about particular lines of research that the company might have to take in order to better understand or better address a particular issue, right? So so far the board has made more than 90 of these policy recommendations to the company in the context of a case decision. One difference between the policy recommendations and the decision in the individual case is that the policy recommendations are not binding on Meta. They are recommendations, but the company is required to respond to those recommendations within 30 days and say whether they've been implemented or not. I think it's fair to say that when the board first got up and running, we did not necessarily anticipate how much of the work would involve making policy recommendations and trying to make sure that those recommendations are sound recommendations. But that has been a major part of the board's work. And as I said, so far, there have been more than 90 recommendations. The company has officially accepted more than half of those recommendations to either implement fully or implement in part. We don't take it on faith that Meta is necessarily implementing our recommendations in the way in which we would like them to. We have set up an implementation committee that is within the board that's designed to try to track Meta's implementation of the board's recommendations. The last thing I'll say for now, before I turn to commentary and questions, is that there's a broader mandate that the board also has to issue what are called policy advisory opinions. This is where Meta requests the board's input on a particular policy issue. So we've received 2 of these requests so far and have completed one of them. So one of those requests involved the way in which the company handles the publication of residential addresses. And one can imagine all of the various privacy issues that it entails if someone publishes a residential address or puts up a photo of someone's address on social media. But at the same time, you may see in a piece of journalism, someone's address has been mentioned or a house has a photograph, or you may see a protest is happening around the address of a public figure. So the company asked the board for a policy recommendation about how it should handle publication of residential addresses. And to date, the company has also asked the Oversight Board to issue policy recommendations around a program that Meta has called Crosscheck, where there is a secondary review process for certain users of the company. And we've been asked to give advice about whether and to what extent or how that particular program should be structured. So that's what we're aiming to do so far. There's a lot more I could say, but I'll pause for now and turn it to a commentary and to questions to figure out, how we're going to what the topics of discussion are going to be for the rest of the session. Thank you.
Thank you very much, Professor. Our next speaker is Professor Theodore Te, Assistant Professor and Director of the Clinical Legal Education Program of the UP College of Law. He is one of the most prominent human rights lawyers in the Philippines, known for litigating freedom of expression and other public interest cases as the NCR Regional Coordinator for the Free Legal Assistance Group, or FLAG. Most recently, he served as counsel to the petitioners challenging the constitutionality of the Anti-Terrorism Act that was enacted in 2020, and which was recently decided by the Supreme Court last year. In 2012, Professor Te was appointed spokesperson of the Philippine Supreme Court, occupying the position until 2018. He received his law degrees from Columbia Law School and the UP College of Law, where he was active in various advocacies and providing legal aid to vulnerable groups. I turn it over to you, Professor.
Thank you, Jenny, and welcome, Professor Jamal. And thank you for allowing me this time to give some comments on the Oversight Board and its functions and its decisions. I won't take a very long time because I think Jamal has answered actually some of the points I wanted to indicate, and I will point that out. But I do have some questions, I think, and so some of my comments will really be in the form of questions or clarifications, and that may I think jumpstart our question and answer portion. The first thing I would probably say is that as many have pointed out, that the decision to create an oversight board is really a welcome development, and it is a very, very good start. And looking at the work of the board so far, including the decisions that it has already handed down, as mentioned by Jamal earlier, I see that the board is well off to a good start, but I would probably give some thoughts or give some ideas to make the work of the board, I think, more consistent and maybe a little bit more predictable and a bit more transparent. The first would probably be something that the board would have heard or read in many public comments, and I resonate with this, that while the board I think incorporates and uses human rights standards in decision making, I think it's a good idea to incorporate it as part of the charter to make it a non-negotiable, as it were. Reading through the decisions of the board, I see consistently that the board cites, for example, human rights standards in its decision making. One question though that would probably still stick out would be in invoking these human rights standards in relation, let's say, to the community standards of Facebook or Instagram, which would be weightier. What value or what weight could we give to human rights standards as opposed to community standards? And while again looking through the decisions, I think most, if not all, of the decisions so far have given premium and a great weight to human rights standards. I think there might be there might be greater sustainability or consistency if these standards were to be integrated and incorporated. And speaking about standards, I think they should be clearer or clear enough, I think, to users. Many people don't read the fine print, as it were, and not a lot of users are familiar with the standards that are being used by Facebook and Instagram and the Oversight Board, of course. So for many, they might not even be aware that some of the things that are being done or said on Facebook may actually be reviewed. And so perhaps, I also teach criminal law, and so consistent with the principle of legality, knowing what you're being held accountable for or what you could be held accountable for, I think there might be some, a greater effort perhaps to make it more transparent or clearer. I also note that the board uses the principles of proportionality, for example, in applying sanctions, and I think that's very welcome because it does provide for a clear standard in terms of how to apply any decisions and how it can be reviewed. But I am not sure, and I don't see yet anything on what remedies would be available for a wrongful removal to the person. While in fact the board has already made decisions on that this was wrongfully removed, and so it should be put back. For the user, for example, whose content was wrongly removed, and I want to situate this within the particular context, let's say, of the Philippines, as it faces an electoral exercise, and in the midst of a campaign against this that leverages on disinformation, where a lot of users can actually be targeted for expressing legitimate political content, but can actually be targeted for removal by opponents or even by trolls, for example. And so if the Oversight Board says, no, that's wrong, you should restore the content, what exactly would be, what exactly could the user look forward to other than the restoration of the content? I'm also keen, for example, on and Jenny mentioned earlier the decision of the Supreme Court on the anti-terrorism law in the Philippines, for example, and I'm also curious as to, for example, how the board would deal with issues of, well, terrorist tagging, profiling by agencies of government who are on social media, who use social media as well. For example, the military or the police have social media accounts. They use that, they monitor it, and they're actively engaging in these practices. There is a distinct practice in the Philippines of red tagging by branding people as communists, which is not a crime, but nonetheless results in very adverse consequences. And so how would, for example, the board look at those things? My third point is perhaps that the review process, any review process, I think, must be consistent in terms of allowing for context and totality of circumstances to be considered, and I see that in the decisions. I've read through the decisions posted on the website, and I do see that. But I think perhaps to be more helpful, it should be more consistent, I think. I read a public comment. If I'm not mistaken, this was by Professor David Kay, where he suggested, for example, incorporating something like the Rabat Plan of Action, something like that. So I resonate with Professor Kay's recommendation, for example, in that public comment, and so. Those would be my general comments, I think, to the work that the board is doing, and I do have some questions by way of clarifications that perhaps Jamal may expound on a little later on. I'm glad that Jamal pointed out that the board in its decision making welcomes public comments, and I am curious, though, from the point of view of one who teaches law and one who also is active in social media and one who is an advocate for freedom of expression, what the role and the weight of these public commenters are in its decision making. You'll probably get hundreds of comments on any issue. So I'm curious as to how the board views these public comments. What goes into your mind? Is there like a collective standard that you look at in terms of these public comments, which would probably be diverse and would probably range from we would probably have a lot of opinions there. So I'm curious as to that. I'm curious as to whether there is any intention to expand the mandate, as it were, of the review of the board. Right now, I think the board is focused on content that has been taken down. But what about content that remains up? What about content that is still there, but has not been taken down because, well, no one has probably complained? And so what about that? I'm not sure where the board is on that. Or maybe issues about data collection, privacy, and those things. And I'm glad that Jamal also pointed out that the board is also being asked to give advice by way of advisory opinions and policies. Although I did note that Jamal pointed out that this wouldn't be binding on the board, on Facebook, on Meta rather, on the company. And I'm curious as to how the board would see its role there. Because I think more than just simply adjudicating on specific things, it would be a greater, it would play a greater value, I think, in terms of providing sustainable advice on how the company could work and to be more consistent with human rights standards. And then maybe my last question, my last comment by way of a question would be. I note from the charter that there is a standard provision that says compliance with law. Nothing in the charter or governing documents shall be interpreted in a manner that would result in a violation of law by Facebook, the trust, the board, or any other associated entity, and that the board will not purport to enforce local law. I don't know if the board has encountered a situation where the domestic law, for example, would be, well, inconsistent with guarantees of freedom of expression, freedom of association, where the law itself is the problem and not just the enforcement of the law, and how the board would probably discharge its functions within that particular context. So I'm sorry, Jamal, if some of these questions would probably be outside the scope of what you mentioned, but these are things that ran through my mind when I went through the board's charter, the board's decisions. And so thank you very much for the opportunity, and thank you, Jenny.
Thank you very much, Professor. Professor Greene, would you like to respond to Professor Te's questions?
Sure, I would be happy to respond and also just to thank Professor Ted for for the questions, which are great questions. So no need to apologize. They're exactly the right kinds of questions, I think, to be asking about this new institution that we've created. I'll try to take them basically in order, since I haven't had a chance to organize them in some other way. The first set of questions were around the role of human rights within the Oversight Board, and you noted that that a commitment to human rights is that would be more permanent if it were part of the charter. I suppose that's right, so I won't push back on that. But I will say that, as you've noted, the commitment to human rights that within the board is very strong and has been very consistent. Certainly, I certainly don't foresee any waning in that commitment. Every case we've decided has been we have placed Facebook's community standards and its individual decision against how the board understands the application of human rights principles, and that our decisions are precedential for us, right? So that is very much within the DNA of what we do as a board. The relationship between the community standards and human rights as well has not been something where there is a clear hierarchy, in the sense that again, in every decision, the board has made reference to the fact that Meta, previously Facebook, has committed itself to respect human rights through the UN guiding principles, and the board understands itself as one of the mechanisms for accountability for that commitment, right? So if a community standard is out of line with international human rights, the board would not hesitate to say that community standard should not be applied in a particular case. So that's how, at least I understand, the board's own work. Let me say a word about, this is out of order, but it may be related to this question, is what to do about domestic law. As Professor Te notes, the board does not weigh in on issues that Facebook or Meta is required by domestic law either to leave up or to take down. When we take a case, the first thing that happens is there's a legal review by Meta where they say, and this has not happened frequently, but they say whether there is some legal problem or some legal obligation associated with the decision that the company made. We have our own legal counsel as well and our own legal staff, right? So in theory, if there was some disagreement about this, that disagreement could be hashed out. But the board is not well positioned at the moment, certainly, to impose legal obligations on the company, in the sense of saying you'd be required to, and the company would not agree to be required to violate the domestic laws of a particular country. But that's not to say that this is not a serious problem. It may very well be that domestic law is inconsistent with international human rights principles, and that is worth calling out, and that's worth conversation. It's just not something that the board, in issuing binding decisions, is able to really do much about. But again, it's a serious issue. There's also a serious issue around what does it mean to say that something, domestic law often has a lot of discretion built into it, and so it can be a real problem when the government says one thing, but the law seems to say something else, and you've identified a real problem is all I'll say for now. in terms of transparency, and this is a hugely important question of, do people who have accounts on Instagram and on Facebook, and do they know the rules? Do they know that they are, what's a violation and what isn't a violation? You know, I could point you to a website, right, that tells you what the community standards say at any given moment, right? But there are a few issues around this, right? One is they're long and they're complicated, and they used to be much shorter, but now they're much longer. And people don't always know exactly whether they're in violation or not. And there's a separate issue of, as with a lot of legal regimes, what are in fact the practices of the company might not be reflected in a transparent way in the community standards themselves, right? So it might say, we take down, you know, hate speech, or, you know, I'm just giving an example, but internally, the directions to its content moderators are much more specific than that. Or the company relies on an algorithm, right, that has its own specific instructions for what gets taken down or what gets not taken down. And as Professor Te says, that can really raise an issue of legality under international human rights principles. If your content is removed for reasons that are not clear to you, that's a human rights problem. We have not been shy about calling out that problem. If there's a single problem that I think has dominated the cases so far and dominated the recommendations so far, it is the problem of a user not being aware of why their content was removed. And, you know, the company has some reasons why they are sometimes hesitant to give full reasons, and it's because they don't want the platform to be manipulated by adversarial actors who, if they know the specific rules, are going to work around those rules. And that is a concern, right? But as a matter of international human rights, if for speech to be interfered with, it does need to be clear what the rules are in advance, and that's something that the board has been hammering on again and again and again with Meta. You asked about remedies available for a wrongful removal, and maybe I'll put this also in the category of something that's beyond what the board as currently constituted is able to do. In theory, and this is something that I'm agnostic about, I won't especially weigh in on, but in theory, under the domestic law of any individual country, it may be that there are contractual remedies or maybe even tort remedies associated with a wrongful removal of content by the company. That's not a matter of board policy, but it could be a matter of domestic law. One could push the board to say, oh, but shouldn't there be some internal process at Facebook or Meta that provides compensation or some other kind of redress, apology, or something when there's been a wrongful removal, which can often be devastating for a business or something that's relying on the platform. And that's a fair conversation to have. It's not something that's currently part of the board's charter but one of the things that I'll say as a general matter is, we want to be part of a conversation in which we play a certain role, which is we make binding decisions on content, we make recommendations that the company is required to respond to, but there are others within civil society who are also important engines of accountability for a company like Facebook, and should continue to push in those directions. There is a question about and I guess this was in the same vein of the specific practices associated with targeting and terrorist targeting and referring to people as communists and that sort of thing. I won't comment on any potential case, right? If this is something the government does a lot, it's potentially something that could show up in the board's among the board's cases. So I won't specifically comment, but Facebook's own community standards does have, they do a bullying and harassment policy that that I would imagine if someone is being targeted in some way that leads to lots of harassment, that's the kind of claim that one could potentially make, but it's hard to comment in the abstract on that kind of issue. There's a question about the role and the weight of public comments, and this is really important. We do read all the public comments. I will say, just in terms of numbers, the decision that the board made in relation to the removal of President Trump's account in January of 2020 received thousands of comments, so many more comments than most cases. Most cases do not receive hundreds of comments. We would like more comments to come in. So this is again a plea for people to weigh in on these issues. But we do pay careful attention to them. And what I'll say in terms of how are they helpful to us, I think in two ways. One is really subject matter expertise, and a lot of the comments come from NGOs or advocacy organizations that may know something about a particular issue. Let's say it's an organization that works on doxing, let's say, and they know what the research is. They've been spending a lot of time working on a particular question and can put it in context for the board. The other is local context, and you would be surprised, if there's a word used or a phrase used, and there are a lot of cases like this where it's not clear. Someone who doesn't know the local context doesn't know how much of an insult is this. Is this the kind of thing that people say on mainstream television, right? Or is this something that is really beyond the, over a red line, or something like that? And we do have local experts who we rely on for that. But just even getting a cross sample of people who say, look, I'm from that area, and let me tell you about what this means, or how I use this with my friends. And of course, we're always going to double check that with experts and so forth, but giving some directions to us to say, okay, here's where it's a kind of crowdsourcing of certain kinds of questions that I think is very important to the board's work. I'll just make two more other points, and then we can take some questions. One is on expanding and they're both in the same vein of what does the future of the board look like in terms of scope and in terms of recommendations. In terms of scope, and I'm sorry if you're getting like beeps and things from my laptop. I don't know how to stop that. But in terms of scope, it is already within the scope of the board to hear what are called reporter appeals, which are someone has reported a piece of content that they say the company should have taken down, and it hasn't been taken down. So that appeals process has been in place for about a year now. So that is part of the purview of the board, and we welcome those cases as much as we welcome cases in which content has been removed. And they're slightly different, right? So when people's content is removed, they're often claiming I have a freedom of expression right to have this content on the platform. If its platform should be taken down, this is causing some kind of harm, or this is in conflict with the community standards of the company. And it should be taken down. And so both those cases are within the purview of the board. As to other issues, you mentioned privacy and data collection. That's not currently in scope. Right now, the board is very much a content board. There are other content issues that one could imagine, advertisements, for example, are not currently within the scope of the board. One could imagine a future not too far away in which that is potentially part of the board's a mandate. I think everyone anticipates, and I think it's fair to say that the scope of the board will expand over time, or at least that's the aspiration. But the board has to walk before it can run, and so trying to figure out how to do the current job as well as possible is the first step. But it's certainly the case that members of the board, and I think people at Meta as well, anticipate that the scope of the board will be greater in the future. And the direction of travel so far has very much been to take very seriously the board's ability to make recommendations to the company. There's only so much that one can do through case-by-case decision-making, as important as I think that is. When we think about broader change, that's going to require a broader lens from which to view these cases. And the best way to do that is through the policy recommendations. And that's going to require, a lot of deep thinking. Is going to require a lot of resources and expertise, and that's all very much a part of the conversations that we have about what the future of the board is really being able to make policy recommendations. But that's something that really that is in a lot of ways more difficult than the individual cases, right? Because there are so many moving parts involved and so much deep expertise and so much data that one would ideally want to have access to. So it's a longer term project, but very much on the radar screen of the board.
Thank you so much, Professor Greene. I will be asking questions from the audience. So the first question we have here, if you are not Facebook employees, who is providing for your compensation to do your job independently?
Great, so important question in trying to understand what is the nature of the independence of the board. I think probably the best analogy to use would be as a kind of independent contractor. So the board is paid out of an irrevocable trust that is established by Facebook. So Facebook does fund the board, but the Facebook is not allowed to retract money that it's been given to the board. It doesn't have personnel control over the members of the board. It can't discipline us or anything like that over decisions the board has made. It can't influence the decisions the board has made. And so the relationship that the company has is again, that's a loose analogy. There's not really anything that's exactly like what the board is, but the loose analogy would be a kind of independent contractor that has a contractual relationship with the company, but has its own independent employees. So that's the mechanism.
Right. The next question is on misinformation, political misinformation. How has Facebook's policy evolved since 2016 when the US presidential elections happened?
So I'll just say that I don't feel totally comfortable talking about all of Facebook's policies. It's really a question for Facebook. But I will say, certainly the problem of misinformation is a big problem. It's a very hard problem to get at. And I'll just say that there are a number of policies that Facebook put in place between the 2016 election and the 2020 election to basically target two different kinds of misinformation. One being intentional, often financially motivated misinformation that comes from content mills, and just being more aware of that particular problem, and the other being political related misinformation that is a little bit, in some ways, the ordinary churn of politics, where you have people making misleading claims of every description, and trying to sift through that. And I'll just say that the dominant response in the election context from Facebook was labeling and directing, when misinformation is identified, to direct users to an election information center that had correct information. So introducing labels, sometimes downranking, so that there's additional friction before someone encounters forms of misinformation. But I won't say much more than that. I'm just talking based on public reports of what the company has done. This is not. This is really a matter of the internal policies of Facebook, and we haven't. The board has not weighed in on misinformation policy in general, although we did have a case involving COVID-related misinformation that I could talk about.
Thank you. Dean Vistan, would you like to ask something?
Yes, Jenny, thank you. Professor Greene, thank you for Jamal. Thank you for your talk. And of course, I think one of the questions, or some of the questions we can see is really about the independence of the oversight board. And I was wondering, and you mentioned like Meta has a contractual obligation to follow your decisions. So I was wondering, what is so does the oversight board, is it a company in itself? And I ask that because I mean, if one aspect of the oversight board, or one possibility that derives from the oversight board being really independent is number one, it can choose to do other things. It can choose to serve other companies, and as you say, expanding its work. Are those things possible? In other words, what is the real nature of the oversight board as an entity?
So again, these are great questions. The oversight board is an independent company, so it's a nonprofit corporation. It's incorporated in Delaware, and so implication of that, could the oversight board engage in other activities or contract with other companies? There's nothing in the charter of the board that prevents it from doing that. And I'm not counsel to the board, so I don't want to speak too much about its internal contracting. But there may be, there may be some contracts that would have to be renegotiated in some way if the board were to take on certain other activities. But there's nothing in the essence of the board that prevents it from doing other kinds of work, from engaging with other companies or contracting with other companies. This is just to anticipate a question, right? This is not something the board is doing right now, but the board is open to, is a work in progress, right? So I think that there certainly are members of the board who think that sometime in the future, having some relationship with companies other than Facebook would be welcome. There are others who think, well, I don't know. So it's one of these things where we'll see where it goes.
Thank you very much.
We have another question. Who audits Meta's oversight board and the so-called fact checkers? I guess fact checkers of Facebook.
So again, great questions. So I take this as sort of two separate questions. One is who oversees Facebook's fact checkers, and another is I'll take audit, who audits the oversight board, to be not a question about accounting, but a question about who holds the board accountable. If we're engaged in conflicts of interest or fraudulent acts or something along those lines, what would then happen? So as to the first question, the board does not have a role in auditing Facebook's fact checkers. It's certainly conceivable that that's the kind of thing that could be within the scope of the board at some point in its life. But that's not part of the board's purview right now. And again, I don't think there's any reason, any principle that would prevent the board from being involved in that process. It's just a different process, as advertising is a different process. So that's not something the board does right now. I assume the company itself has some process for reviewing the performance of its fact checkers, but I'm not privy to that. On the second question about the board itself, so the board has trustees who are in charge of the trust. That the board is set up as a nonprofit trust, and it has trustees, and they are under a fiduciary duty to make sure that the board is functioning in accordance with its charter, and that includes the performance and evaluation of individual board members. Right. So if board members aren't doing their job, or if there's a conflict of interest, then that's something the trustees are able to deal with. And that it is set up in that way because, again, the board is not a part of Meta, so Meta can't review the board's work or discipline the board's members, but the trustees are able to do that.
There's another question. Could you share some insight as to what factors Facebook considers in deciding whether to impose a suspension vis-a-vis other measures such as flagging, downranking, etc.?
Gosh, so I think generally speaking, and this is maybe not something, so the first thing I'll say is this is a Facebook policy question, right? So the board, right now, what the board is able to do in a binding sense is to say that Facebook must either take something down or leave it up. Questions about account related issues, so whether someone's account is suspended or should be not suspended, downranking of content, applying labels, none of those things are currently within the mandatory toolkit of the board. So we can't order Facebook to restore someone's account or to suspend them, nor can the board order Facebook to downrank content. Or again, as with other matters, there's no reason in principle why something along those lines could not be in the future of the board. And I think there are certainly many board watchers and people internals to the board who think that that's an important part of the board's future. But that's not within the initial jurisdiction of the board. But the general question about, you know, when is something downranked versus having someone's account suspended, it really depends on the severity of the conduct. And Meta has its own internal hierarchy of what counts as a severe violation and what counts as a less severe violation, what kinds of materials will get downranked versus removed. They have their own internal processes and their own internal algorithms that determine those questions. And so that's really a matter for the company rather than the board. What I will, at least at the moment, what I will say, just by way of addendum, in case there are people who are wondering about this, I've just said account removals is not one of the things the board does, but the board's highest profile case was an account removal, or in this case, an account suspension of President Trump. And so this is actually an opportunity to say one other thing that can happen is not all of the board's appeals come from users, but some of the appeals come directly from Meta. So the company can say, we would like you to review this, even if a user hasn't necessarily appealed to the board. And we have taken some of those cases. Those cases can be outside of the kind of default jurisdiction of the board, right? So Facebook could ask us to tell it to make a decision about an advertisement, or could ask us to make a decision about, in the case of President Trump, about his account suspension. So the reason the board had that case was because it was a direct referral from Facebook.
There's another question. Conceding that Meta might not actually enforce the Oversight Board's decisions, if a party were interested in seeking judicial enforcement of an Oversight Board decision, or if a judicial body were interested in enforcing the board's decisions, do you think that judicial relief should be made available?
So I won't comment one way or the other on whether the judiciary within any particular country or region would take an interest in the board's decisions. You know, I will say, as to implementation, you know, the board has an implementation committee that monitors implementation of decisions. It hasn't been an issue, and I don't anticipate it being an issue, as to whether the company will, you know, restore a content that the board has said it must restore, or remove content that the board has said it must remove. This is something that's quite easy for someone to to identify if the company doesn't respond to the board. And so I don't anticipate that being a problem. It's not in the company's interest for it to defy the board. Where it gets more complicated, and there are really real questions about this, is when there is different content that is somewhat parallel to other decisions that the board has made, and this is really something that the company is only obligated to respond to the individual piece of content, but often, content is often there are often very similar cases in other postures, and so one of the really difficult and really interesting problems is if the company how does the company identify similar cases in parallel context? How does it integrate into its content moderation system an instruction to remove similar cases? This is a kind of it becomes an engineering problem, right, and not just a problem of should an individual piece of content be removed or not. And one of the challenges of the board and over time will be how to engage with, and this is part of what the implementation committee is working on, how to engage with systems design to make sure that the board's decisions are not just implemented on the one individual case, where we're not too worried about that, but Facebook systems are designed in a way that takes account of the board's written decisions, and that's a very complicated process that actually requires some engagement with the company, right? The board can't be entirely arm's length if it wants the company to be able to respond to its decisions.
How does the status of the speaker factor into the board's decisions in dealing with speech that potentially incites violence?
So this is, Professor Ted mentioned the Rabat Plan of Action, which has some things to say about this question. It's really contextual, right? So, without talking about any particular case, so actual incitement of violence, if that's what we're actually talking about, if one has reached a conclusion that someone is engaged in incitement that violates the community standards of the company, and that and assuming the incitement is fairly strictly defined, is not protected by international human rights law either, as or at least it's a way in which one can interfere with speech if it's actually causing violence to others. But the question of when, under what circumstances that might actually happen, is a highly contextual question, right? So if I walk outside of my apartment right now and I say, let's storm the White House, and I stand there in the middle of Broadway and say that, I can't be punished for saying that because there's no real possibility that that's about to happen. But if I'm standing in front of the White House armed, and I say to a bunch of people who are also armed, let's storm the White House, that's a very different situation. And who I am, right, might very well factor into that question, right? If I'm a nobody and no one's really listening to me, it might well be different than if I'm a leader, if I'm someone who people are likely to follow. So it's a very contextual inquiry. It is not the case that that only people of certain status or only people in certain positions can engage in incitement, right? It's always going to be contextual. But I think part of that context is, what is the likelihood that the things that you say are going to be listened to? So that's where I'll leave it. And I'll just say, in case it isn't clear, the standard under international human rights law for incitement is quite a high standard, right? So it's not that easy to be guilty of incitement.
I think your earlier responses already addresses this question, but let me ask this. What is former UK Deputy Prime Minister Nick Clegg's role in the Oversight Board, if any?
So Nick Clegg doesn't have any current role in the Oversight Board. He has an important role at Meta, and he is the within the company, since he is in charge of global policy, and the Oversight Board is sort of part of that, is under that umbrella. He is the person he's one of the people at the company that the board who has a relationship with the board, but he has no internal relationship to the board, right? So he doesn't weigh in on the board decisions. I've certainly never spoken to him about any cases the board has decided or anything of that nature. So basically none. I mean, he's a point of contact at the company, but he has no he doesn't have anything to do with the case decisions of the board.
Right. I have two related questions here from two different attendees. The first one is, considering that Meta is a multinational corporation that serves almost all countries, perhaps it is safe to say that it would really be overwhelmed by complaints, etc. Is there any plan to domesticate the Oversight Board in countries where Meta serves? And another related question to that is, what can the Oversight Board do to be able to listen to more cases?
So great. So on the first question, I'm certainly not aware of any plan to domesticate the Oversight Board to local context. There's a, I've said a few times that there's no obstacle in principle to certain kinds of expansions of the board. Here's one where there may be an objection in principle, which isn't to say it shouldn't be done, but is to say that one would have to think carefully about it. Is that part of the board's focus on international human rights law is to focus on a body of law that is truly international, is truly global, and anytime you create institutions that are local, they develop their own set of practices and their own way of doing things. There may be benefits to doing that. I mean, when we talk about governments and we talk about whether to have a unitary or a federal system, right? We talk about those kinds of questions. What are the benefits of localism versus the benefits of centralization? And as the board is currently constructed, it understands the benefits of having a single body of rules be as quite important. So there aren't plans to do that. I think if that were to happen, we'd have to think carefully about how to structure it. On the, can you remind me what the second question was?
What can the Oversight Board do to listen to more cases?
Oh, how can the board hear more cases? So I think the most straightforward answer to that question is the board to be larger. So right now the board has 20 members. As initially contemplated, the board would have twice that many, so 40 members. And we are very actively in a membership selection process. And our hope is that in the next several months, we'll be able to announce new members that would enable the board to take more cases. So that's an answer to that question on one level, which is, we could take quite a number of more cases if we had more members. But there's a broader question of, could the board, right now we've taken 23 cases. Could the board take hundreds or thousands of cases a year? And we're not as currently constructed, especially close to being able to do that. And in order to do something of that magnitude, the board would have to be, I think, much larger than it is. Which isn't to say that's not something that could happen in the future, or have a bigger staff that can go through cases more quickly. What I will say is, I'm not sure that that is necessarily the direction that the most effective use of something like the board. The company has its own internal content moderation appeals process. There are certainly ways in which that process could be better. I will be the first person to say that there are lots of improvements that the company could make in its internal process. But the board is really about taking exemplary cases that that implicate some broader principle or some larger set of cases, rather than what a court would refer to as error correction, right? It's not just about making sure that the right decision is made. That's really something the company should be focused on. What the board is about is announcing broader principles. And that's not something that one can do well if one is taking hundreds and thousands of cases. It's really something that you have to take time and devote resources to each individual case and deliberate very carefully. That's a matter of trade-offs, and I'm just articulating some of the benefits of having a smaller docket.
Professor, in your view, is having an independent government supervisory authority more effective than a private entity like the Oversight Board in regulating content?
So I don't know. I mean, I'd have to know, you'd have to know what the structure of that particular government entity is. The board doesn't take any position on government regulatory bodies and how they may interact with content moderation. There are ways of doing that are consistent with what the board does. And there are ways of doing that would be inconsistent with what the board does. But we don't have any particular comment on that. What I will say more broadly is that the board as an experiment is designed to solve what I think of as a problem of trust, right? That you have a private company that has its own particular incentives to moderate content in some way or other. And an individual user or society more generally has lots of reasons not to trust that company or not to believe that that company is acting in the interest of its users or in the interest of society more generally. It's a private entity, et cetera. The other extreme, so that's one reason why why a company that just engages in pure self-regulation may not be ideal. But the other end of that spectrum, where the government is the one that is making decisions about content, is deciding what gets taken down, what doesn't get taken down, is issuing directives to the companies, also has a very serious trust problem, and in some ways, I think, globally speaking, a more serious trust problem, given the partisan or political incentives of governments. So the board is is an effort to try to create something it's in a different space, that doesn't have the incentives that a private company has, and also doesn't have the incentives that a politicized government has. So that when it makes decisions about content, we have some reason to trust those decisions. That doesn't mean that the board is ideally structured. It doesn't mean that we've solved the problem of figuring out a third way of doing things, but the aspiration, I think, is an important aspiration. And I think the board is an important step in the direction of that aspiration, which is to try to create institutions of trust, to engage in this really important task of moderating within these kind of new spaces. Not new, they're now almost 2 decades old, but in the history of human communication, new spaces.
What can you say about the group, the Real Facebook Oversight Board, where they expose Meta's questionable decisions?
So I'll say I'm aware of the Real Facebook Oversight Board, and I'll just say that they do something different than what we do, which is they're critics of the company, they're critics of the Oversight Board as well, and there's in that sense, when I mentioned the importance of civil society groups that engage in criticism and try to hold companies accountable in a different way in which the Oversight Board does, I think of the self-entitled Real Oversight Board as part of that. And so I have no, I have no particular criticism of the Real Oversight Board. I think it's important to have organizations that are critical of Facebook and that are critical of initiatives that Facebook starts, like the Oversight Board. I think the really critical difference between the Oversight Board that I'm a part of and the so-called real Oversight Board is that we have the power to issue binding decisions, and so we focus on writing opinions and trying to connect the content moderation to human rights principles, and the company is required to respond to things that we say, and so that gives some mode of accountability to the company, and that's really important, right? So I just think that's just different work than what the so-called real Oversight Board does, but they can do their work and we can do ours.
So I'll take last two more questions and then we'll wrap up. So one question is, if a request for takedown is grounded on domestic law that might not have a human rights dimension, such as an intellectual property rights violation as set forth in domestic law, would the Oversight Board decide on the basis of enforcing this domestic law?
So the Oversight Board does not have jurisdiction over copyright issues. And relatedly, if a removal is because of a need to comply with a domestic law, that's not something the Oversight Board weighs in on. And as I mentioned earlier, weighing in on that would mean issuing a binding decision requiring Facebook to violate domestic law, which is not something that the board, that Facebook has agreed to do.
Our last question is from Professor Adrian Bustos. Good morning, Professor Greene. Professor Te mentioned that having the Oversight Board is a good start, taking into account the objectives of the board and of Meta in creating the Oversight Board. What do you think should be the next step?
Well, I do think there are a number of ways in which over time it will make sense for the board to expand its mandate. And so I think there are, right now, the board just doesn't, for example, handle advertisements. It doesn't, for example, handle issues of moderation of content within groups on Facebook, for example. It doesn't handle account-related or account-level suspensions or strikes, right? So those kinds of so in the relatively short term, I think those kinds of scope expansions will make some sense. I think in the longer term, one of the things the board has really been focused on is transparency, and I think not just the board, but civil society more generally has been focused on transparency of social media companies in how they moderate content. And I think the board can be, over time, an important engine for making sure that companies are as transparent as possible about both the decisions they make and how they make decisions, which are sometimes made by machines and sometimes made by humans. And so I think, again, I think over time, I think trying to be part of making the company as transparent as feasible is I hope within the future of the board.
Thank you very much, Professor. At this point, I'd like to invite Dean Vistan, Professor Te, or any member of the faculty to respond to any of the insights shared by Professor Greene. Professor Te, maybe you have, or Dean Vistan, I see you.
Oh, yes, thank you, Jenny. Well, it's been an interesting talk with Professor Jamal Greene, and we do hope that as you do more of your work, as you encounter more problems and perhaps more issues and difficulties, we get to talk to you again and perhaps exchange. We can also share possibly our own experiences relevant to your work. But at this point, I'd just like to thank you again for your time and for sharing with us very valuable insights into the work of the Oversight Board. Thank you again. Thank you.
Thank you.
Professor Te?
Well, no, I won't add to what Professor Jamal has mentioned, and other than to say thank you, but and also to point out that for a social media crazy country like the Philippines, where a lot of people are on Facebook and on Instagram, I think this was a very interesting and valuable conversation. And as Professor Jamal mentioned, we should have continuing conversations on some of the issues moving forward that the oversight board might be willing to take on or might eventually take on. So I do look forward to that. And so as the dean has mentioned, perhaps this wouldn't be the last time that we'll be having this conversation. So thank you very much.
Thank you. And with that, we will conclude the event. Thank you very much, Professor Jamal Greene. And thank you everyone for joining. Have a good day.